Well, it looks like we're live. Facebook ain't letting me go live, but we live. What's going on, everybody? How y'all doing? We are back in effect, back in the building. It's been a rough few days. I'm gonna give it a minute before I get started, but I'm gonna give up on this Facebook situation. How y'all doing? This is your brother Shabazz. Sometimes Professor Shabazz. Retired Professor Shabazz. What's going on? I'm gonna start off just by saying peace to all the positive people in the universe. That's what I like to start off with. What's good, Richmond, Virginia? And Hotep to the Pan-African Black world. And everybody else, if you don't consider yourself a Hoteper, if you don't consider yourself a Pan-Africanist, but you do consider yourself somebody that likes to put puzzle pieces together and look beyond the smoke and mirrors to get to the real truth. That's what we're going to be doing tonight. That's what we do every time we go live. Now, if you're new to the channel, if you're catching this live or if you're catching this on the replay, if you're new here, hit the like button, subscribe to the channel, and hit that, what do they call it? The notification bell. When it pops up, hit the all. Don't hit the personalize. Because YouTube play funny games when you hit the personalize, which means they don't ever send you anything. So if you're gonna hit a button, by all means, please hit that all on the notification bell. Yeah. So I am trying to slow walk it just a little bit, get everything slated. I was supposed to send off some notifications, and I'll be honest with you, I was supposed to send these notifications off earlier this morning at the latest. But y'all know life be life. I wasn't even sure I was gonna make it back here to go live tonight, but we here. It's on and popping. We're talking about Judge Joe Brown tonight. Yeah, the infamous Judge Joe Brown. So we're gonna go ahead and get it started. Like I said, let me see if I can pull up. We're gonna get into like what you call, so we're gonna get into some legalese. Now, I ain't no lawyer, and I'm not pretending to be one. But you don't have to be a lawyer to know that something ain't right when certain people say certain things. And so we're gonna be talking about this video that popped up, was sent to me. And I'm gonna tell you straight up, before I even play any of the clips, I'm gonna tell you straight up, because they're basing at least some of, if not all of their commentary is based on a question that was posed to Mayor Brandon Johnson in Chicago. And so before we get into anything, let me just make sure I'm putting myself on the record correctly. And what do I mean by that? What I mean is Mayor Brandon Johnson was right. Clarence Thomas, Judicial Watch, are no friends of black people, of the black community in any way. So just because someone might say, well, you know, they have a really good opinion about, hold on. I ain't never been under the impression, and if I was, it was a false one, that Clarence Thomas did or said anything that would help and benefit black folk. And so anybody that's trying to co-sign Clarence Thomas, I have a lot of questions about them. And so, like I said, I wanted to just put it out there. I agree with Mayor Brandon Johnson. And when he says that he's not aware of anything Clarence Thomas has ever done that benefits black people, stellar observation. Now, I'm going to play this clip. I'm going to pull this clip up so you can see exactly what it is I'm talking about. And let me see if we can turn this music down. Don't want it to overcrowd. So we're going to go ahead and try to play this clip. Y'all let me know if you can hear it.
Thanks, opinion, but anyway.
We got it.
But as far as, you know, any lawsuit, yeah, I'm not aware.
Foundational Black Americans saying that it's discriminatory. Judicial Watch
Here we go. Starting up with
Judicial Watch.
Just to set it up so you know what's going on. Now, Mayor Brandon is giving a press conference. Let me see if I can get this better into the screen. Everything is all chopped off. Might not be able to get it any better than that. But Mayor Brandon Johnson is giving a press conference. And so he's asked about this thing that's going around about reparations. So the reporter asks this question.
Watch is suing the city of Chicago over its reparations task force, saying that it's discriminatory by race when you said it wouldn't just benefit blacks, especially foundational black Americans. Doesn't deviation from recently supported case law to institutions of higher learning, where Clarence Thomas laid out a legislative package, make the program unnecessarily vulnerable, status by race versus status by injured class?
Yeah, I'm not aware of anything that Clarence Thomas has ever done that has benefited black people.
Well, I just told you.
I mean,
So that's quite interesting. Like I said, just straight off the top, he was like, I'm not aware. He says, I'm not aware of anything Clarence Thomas has done. Now, the reporter or the person, I don't know if it's a reporter or not. So the person asking the question said, well, I just told you. Judicial Watch. Now, it's very interesting. I don't know who the person is, and I don't know what their motives are. But the way he leans into this whole thing is like he's making it seem as if he is truly concerned. He might be, but he's making it seem as if, I'm going off the strength of Judicial Watch. And so I'm like, well, here's part of why I got a problem. So just, hear me out. So the question at issue is that the question in this interview, okay, maybe we can put aside the Clarence Thomas thing, maybe. But the question was about the lawsuit brought by Judicial Watch. Now, Judicial Watch is against reparations policies. So Judicial Watch is a group of people that's like, every time we see black folk doing something, we're going to see if we can challenge them in court. So to lean into thing like, yeah, but Judicial Watch said, it's okay, wait a minute. I mean, I know you got to keep your enemies closer, but you don't ride with them. So now the purpose of tonight's conversation is to debunk all of this stuff. But before we debunk the legal claims in the video, we do need to understand who we talking about, who we dealing with. We need to understand who Judicial Watch actually is. Now, Judicial Watch, as I said, Judicial Watch is not, keep this in mind, it's not a black legal advocacy group. They have those. They're like the NAACP, and I know y'all gonna be like, well, they ain't really doing nothing. I'm here to tell you they're doing more than what you think they do. They may not be doing what you want them to do. They may not be doing what another group is doing, but they doing things. All these organizations that are out here are doing things based upon what they set up in their constitution and bylaws to do. We need to get away from this soundbite culture, this just repeating sound bites. Now, I know it was real big 10 years ago. It was real big 20 years ago for a certain types of speakers. I don't want to necessarily say leaders, but speakers, to get up here and say the NAACP ain't doing nothing. And I'm like, wait a minute, but the NAACP in California is the ones almost at the absolute vanguard of getting reparations policies put in place. They ain't got there yet, but they're doing something. So we got to get away from that. But the only reason I bring it up is because there are organizations who are considered black legal advocacy groups. So if they tell you, well, maybe we got a problem with that, then you're supposed to pay attention. But when an organization is listed and labeled and is proud of its conservative legal activism, You're not supposed to take their word when they say we got a problem. No. They are an organization, Judicial Watch, files lawsuits challenging government actions, most often, against Democratic officials, often against Democratic legislation, often against anything that they can say, ooh, it look like they trying to help one of the races. Look like they're trying to help a non-white group. They get the cracking. So just because they rear their ugly head doesn't mean you jump up and say, uh-oh. You know what, massa man? And so again, Judicial Watch, and maybe I should pull this up. Somebody be like, you don't know what you're talking about. Let me see if I can pull this up. Let me see. Stop the share. Share the screen. And can I find this thing to pull up? So let me see. What are we seeing here? So here we go. We see Judicial Watch here. And as you can see on the screen, Judicial Watch is an American conservative activist group that files Freedom of Information Act lawsuits to investigate claimed misconduct by government officials. Now that sound like what we supposed to be supporting. Yeah, it sounded regular, it sounded innocent, it sounded normal when Elon Musk said it. But Judicial Watch primarily targets Democrats. They targeted Bill Clinton, and I'm not here to be defending Bill Clinton. They targeted Barack Obama, and I'm not here to defend Barack Obama. But you can check that out if you want to know who they really are. My point is, they are not friends of the black community. They are not friends of black advancement. They're not a black legal advocacy group. So let's be honest, Judicial Watch is no more a friend of the black community than Edward Bloom. Well, who is Edward Bloom, you might ask? Edward Bloom is the founder of the American Alliance for Equal Rights. Does that ring a bell? That's the group that sued the black women who created an investment fund, the Fearless Fund. Judicial Watch is pretty much just another version of Edward Bloom's AAER. Now, I don't know if you know who that is. You should. And if I can, I will put them on the screen as well. Let me see if I can throw them on the screen. Take this off the screen. Stop that share. Share this screen. This is who we talking about. So you see these sisters on the screen. Now these sisters came together to ensure that there would be representation, that there would be financial assistance for black women that wanted to create businesses. And what happened? Edward Bloom got his little watchdog organization, the American Alliance for Equal Rights, to sue them over a grant program that specifically supported black women entrepreneurs. Now, they argued that the grant contest violated federal civil rights laws. And as a result, the Fearless Fund shut down that program entirely. So you got to understand who you are siding with when you jump up and down and say, well, what did Judicial Watch say? What did the KKK say? If we keep it plain and simple, Those AAER lawsuits led to closure of the Fearless Fund's Black Only Strivers Grant Contest. It was a contest. So Judicial Watch, the AAER, Edward Bloom, unfortunately, we gotta throw a dear elder. I don't know how dear this elder is anymore, but we gotta throw a dear elder onto this gravy train of hate. Judge Joe Brown and his co-host, assistant, YouTube partner, whatever, Dana. They're essentially playing the Edward Bloom legal game. They're not defending Black progress. They're trying to use the law to block programs designed to address racial inequality. Now, if you feel me, if you believe me, if you understand, or if you're okay, maybe you don't believe me, not yet. Just pay attention, keep going. We gonna cook. Because if you're ready to see why it's all so wrong, hit the like button for me, subscribe, share this video right now with somebody else. Whether you're watching vertically or horizontally, I don't care. Share the video with somebody else. Let them come on in here. We can kick it. We can talk about it. And I'm gonna go ahead and, so we're gonna continue this. Let me see if I can pull them. Let's see, remove them from the screen. There we go. Now we back on the screen. So I showed you the sisters, I showed you what they was doing, and I showed you what folk like Judicial Watch was trying to do. Now I'm gonna play a section in their video. Let me see if I can pull this up. Right, so we're gonna pull this up and I'm gonna play this. You know, remove that. Stop the screen. All right. This thing don't work like it's supposed to. Okay, so now we're gonna get this onto the screen. Now I'm gonna let you listen to what they say. So here we go.
Somehow we're doing the opposite of that.
For almost 60 years, we've been telling the woke crowd that you cannot do what this character is talking about. You cannot put a preference from a group or a group into law unless you make a manifest demonstration that it is restorative rather than something else, because there's always been this consideration of reverse discrimination. The whole civil rights era was predicated on Black folk being treated as inferior because other people were treated as having more rights. Orwell's all animals are equal / but pigs are more equal than others. So what he's talking about with his version of reparations, and as he foresees the law needing to become, is that Black folk become more equal than everybody else in the scheme of things. And if it's not neutral, you can't do anything.
Now I'm gonna put a pause there. Don't want to play too much anyhow. But we're gonna unpack this. Peace to Noah Meadows, who joined in on the chat. What's going on? How you doing? Where you listening from? Where you watching from? Put that in the chat. Let us know. Now, so let's unpack this. Let's unpack this. Now, so Joe's argument, and I do mean Joe. I don't know how much longer I'm gonna call him Judge Joe. Joe's argument here is partially true. I ain't gonna take that from him. My problem is his argument is, though it's partially true, it's wildly misleading. Now, yes, legally, any reparations program has to be remedial, meaning it has to address an identifiable harm. Let's stay focused on that. Address an identifiable harm. But here's the nuance that he's missing, or somebody that's telling him to say this stuff is missing. Because reparations can be targeted at a historically harmed community. Well, what do you mean? Historically harmed communities would be descendants of enslaved people, It would be victims of discriminatory housing policies. And when you target such historically harmed communities, that's not unconstitutional. So his claim about neutrality, now that's what trips most people up. Neutrality here doesn't mean that you have to treat everyone the same regardless of history. It's not what it means anywhere, not legally, not in the courts. Not even in everyday common speak. Courts have repeatedly recognized that programs addressing documented historic injustice are allowed, can actually target the affected group and still comply with the Constitution. That's the exact framework. That's how the Japanese internment reparations came about. That's how Native American redress programs worked. Redress programs. They were remedial, which means they were based on remedy. When I say remedial, let me make sure I make that clear. So when I say remedial, let me throw this on the screen. Remedial equals remedy. Somebody gonna sit there, you trying to call people stupid? They ain't that's not what remedial means. So remedial means remedy, of or related to remedy. So let's make sure we got that straight. So again, whether you're looking at the Japanese internment reparations, whether you're looking at Native American remedial redress programs, they were both remedial, they were not neutral, and the courts upheld them. And so we got that. Now, the other thing he said, reverse discrimination. I am so ticked. I expect certain white folk. There are some white folk that understand that the whole reverse discrimination rhetoric is bogus. But okay, I don't expect the MAGA oriented, the Republican adjacent, the conservative closet Republican voters. It's a game, it's a scam that they're trying to run. And so this whole reverse discrimination rhetoric is a scare tactic. The Supreme Court, in cases like Regents of the University of California versus Bach, that's like the landmark case back in 1978. And another case, Grutter or Grutter, depending on your proper pronunciation, Grutter versus Bollinger in 2003. Both of these cases clarified that race conscious remedies are legal. They are legal if narrowly tailored to address past discrimination. In other words, reverse discrimination doesn't automatically invalidate reparations. That's just what it means. That's the legal standard, so to speak. And finally, the other thing, because he wants to bring up Orwell, the Orwell analogy, all animals are equal, but pigs are more equal than others. It's dramatic. It's cute. It's a dramatic flourish, but quite frankly, that's not legal reasoning. It's meant to scare the viewer into thinking reparations somehow give Black Americans. Oh, let me say that again. It's meant to scare racist white viewers and self-hating Black Negropians into thinking reparations somehow gives African Americans, the descendants of the enslaved Africans who are the harmed group community, more rights than everyone else. But that ain't how the law works. The law is clear. if you are focused about repairing harm, not granting privileges. Then they can spin it and try to say it's about granting, reparations is granting privileges. That's spin. That's false narrative. Reparations is about repairing harm. So equal protection and strict scrutiny, that's the standard. That's the standard that they're alluding to, and they ain't talking about it, and they ain't clarifying it. I wonder why. Because if they bring that up, if they explain it, then they have to justify their misinterpretation. But their entire reasoning stems from something called equal protection and strict scrutiny. Let me put that on the screen. Let me put that on the screen. Let me try to put that on the screen. Because that's what we're talking about. We're talking about equal protection and strict scrutiny standard. Now, again, I got to say, if you're just joining in, I see a couple of people popping in and popping out or whatever. I appreciate your presence. So hit the like button, subscribe to the channel. Share this with somebody that's interested in law, politics, reparations, Judge Joe Brown. But we're going to keep it moving. We're going to keep it moving. Let's move on up to his next little claim. Let me see if I can pull this together. No, not yet. So, okay, now we're going to pull this on up. Let's see what else he has to say.
Not remedial, and right now, look at it. He's mayor of the third largest city in the United States that used to be run by Al Capone, the Dalys, Senior and Junior, and a machine. And by the very fact that he holds the office he holds, where he holds it, illustrates that there is no longer a remedial necessity for this thing. So if they can't...
Now, hold on. Did y'all catch what he said? Y'all understand what he said? Basically, he said there's no remedial necessity. There is no need for a remedy for the harmed community, the enslaved Africans, and their descendants. There is no need for a remedy because there are black people in power. That's what he is saying. That's his legal argument. You know, Mitch, what is it? Mitch, whatever his name is, old Mitch, old man, grave digger, Robin Mitch. He said the same thing. There's no more racism because we elected a black person to be the president. That is the nutshell of what he is talking about. Now, as gravely ridiculous as that is, I don't want to go too emotional. I'm going to try to maintain my academic composure. I will tell you this. The notion that remedy is not needed because an African-American person, I don't care about the folk that said, well, he really was. Shut up. The fact is, it was a black dude that sat in that office for 8 years. But the fact is, the notion that having black people in office means no harm, no foul. Just because some black individuals hold off political influence or sit in the top chair, that doesn't erase the structural damage, injury, and harm that occurred, that transpired, that systematically fought to stay in existence, and that reparations seeks to address. Now, this is the same, I'm going to get in my bag for a hot second. This is the same intellectual drivel that came from old white Republicans. Yeah, I think I already said that. So what I'm saying to you is, I'm trying to say this the best way. If it was stupid when Mitch said it, if it was wrong when Mitch said it, if it was dumb when Mitch said it, if it was insensitive when a white man says it, it's just as stupid, wrong, dumb, and insensitive when a black man says it. There's no sage wisdom in those words. Now, I don't mean to sound disrespectful, and I especially don't mean to sound disrespectful to an elder. But if you're wrong, you're wrong. Courts don't decide equal protection cases based on who holds office. Well, at least not until the Trump era. Otherwise, they could have, if that was the case, then they could have told the Japanese Americans, we don't owe you nothing because there was a Japanese American in office. Didn't you guys just elect somebody? Courts don't work that way. At least they're not supposed to. Now, if you get to the point where that's the only way that courts work, well, then you no longer are living in a democracy or a republic or anything that they tell us that we live under. And we have another whole conversation about fascism. But as it stands, courts look at the injury. They look at the harm. They don't look at who's in office. They look at whether the policy design addresses legitimate injury, legitimate harm, and whether or not it meets constitutional standards. If it does, it can pass constitutional muster. If it doesn't, it can fail. So the claim in Joe and Dana's video is not rooted in legal reasoning. It's rooted in rhetoric. Now, we all know we say things just to sound good when we're dealing with rhetoric, when we're dealing with polemics. And so, yeah, keep that in mind. Judicial Watch sued Evanston's reparations program as unconstitutional on equal protection grounds. That don't mean they had the legal wherewithal. If you follow what I'm saying, hit the like button, share this video. Now I'm gonna move on forward. Let me pull this up. I'm trying to pull this up. But and we're going to get this on down here. So let's see what else the dear elder has to say.
Treating something that is typically Democrat Party stuff. The man pointed out, well, this is in his written opinion. It is law for the United States of America, and you want to disregard it?
Well, if it's not race-based, that would benefit foundational Black Americans' claim to reparations, because I just want to...
Here we go. So, now I may play a little bit more, but let me put this on the screen, because the root of that argument, let me throw this up there. The root of the argument, American law is predicated on equality of treatment. That's what they're saying. Really? American law is predicated on the equality of treatment? Really? Now, we all know just how much equal protection we've had under the law. And we all know just how hard or hit them streets and prove to the judges that it ain't working the way you say it is just because it's written on the paper you say it is. So now how you gonna skip this, how you gonna ignore this is beyond me. But let me a little bit more of what they were saying. Here we go. Add to the stage. Check it out.
Right. And that is just where you cannot do anything that's race-based.
That's right. That's the current law.
But now the mayor comes back and say, when you said it wouldn't just benefit blacks, especially foundational Black Americans, doesn't deviate from recently supported case law to Institute of Higher Learning, where Clarence Thomas laid out a legislation package, make the program unnecessarily valuable, status by race versus status by interclass. That's what the reporter said. Because
whoops, where did we go? Oh, so here we go. Back in the building. So y'all heard what she said. Now here, Dana's taking the center stage. Dana claims you cannot do anything that is race-based. Y'all heard her. Now here's where I rigorously disagree. She says you can't do anything race-based. This is what I'm talking about when I say, okay, so she's leaning into the strict scrutiny standard. But here's the thing, strict scrutiny doesn't automatically block a program. Now it does. I ain't lying, I ain't fronting, it sets a high legal standard. But that high legal standard can be met if the policy is carefully tailored to remedy historic harm. Now, we're not talking about loosey-goosey folk that don't know what they doing. We're talking about lawyers, expert lawyers, who know what they got to do when they go into this courtroom. But here's the constitutional nuance that seems to be missing. Equal protection does not automatically rule out race-conscious policy. It triggers strict scrutiny. It triggers high standard. But it's not an automatic ban on race-conscious solutions. Now, we might be getting into some legalese for a hot second. So let me say it this way, because you can go and by all means, you can look it up. I did. You can Google it. I did. And here's the assessment. Strict scrutiny isn't some magical, unblockable wall that says no reparations ever. If it were, the Japanese wouldn't have got theirs. But I'm going to do you one better. Because strict scrutiny was invoked in the case of Loving versus Virginia. Now, y'all know what that case is. That's when the melanated individual wanted to marry the non-melanated individual. The state tried to tell people who they could marry. And they made it based on race. And the Supreme Court said, nope, that's unconstitutional. Now that's strict scrutiny in action. But the plaintiffs won. Meaning the party who wanted repair won their cause, won their case. So again, strict scrutiny doesn't mean you lose. It means you have to have a strong case. Now there's another case referenced as Shaw versus Hunt. Now in that case, racial gerrymandering was struck down. And it too was a case that involved or invoked strict scrutiny. So we got the Loving versus Virginia where the couple won. And we got Shaw versus Hunt where what was called a racist law was struck down. Now, if you do your research, you're going to find out, yeah, the Shaw versus Hunt, that was white plaintiffs. And they was belly aching about racial gerrymandering. But that don't, you can't say, the white people won and the black people lost. Slow it down. The point is this. strict scrutiny, because this is what they're talking about, and this is why they are basing their commentary. This is how they're rooting their commentary. Strict scrutiny is a test. It's not a wall. You can win, even though strict scrutiny is invoked. You can lose, even though strict scrutiny is invoked. It all depends on the merits of the case. And for any legal beagles out there, come check me. Look up Flores de Otero. Look up the Child Online Protection Act. In all these cases, the government failed the strict scrutiny test, and the plaintiffs, the people who were identifying a harm and wanted to be redressed, they wanted what was owed to them. In all of those cases, they came out on top. So again, just because strict scrutiny, oh no, run. The point is this: if the cause is right, if the lawyers are skilled, and if the case is compelling, you can win. You can win. I'm not saying that it's a promise. I can't give you no guarantees. We ain't got no guarantees on nothing. But the real barrier to reparations is not the test of strict scrutiny. The real barrier to reparations is the human political actors sitting on the Supreme Court who are predisposed to block race-conscious remedies. And in particular, that is Clarence Thomas. I'm not saying he's the only one. I'm saying he is definitely the bulwark. And so anybody that thinks that Clarence Thomas wrote a statement that gives African Americans a position, a pathway to better argue in favor of reparations, hey, I think you smoking something. And that is a legal misconception that Joe and Dana repeat incorrectly, repeatedly. Now, if you feel me, hit the like button. If you don't feel me, hit the down button. I don't care. Leave a comment on the video page. But I'm going to go on. I'm going to play this next section, because that's when it really gets interesting. Let me see if I can. There we go. So we're going to play this next section. Listen to what they're saying now, because this is about, maybe I should put this on the screen. They're talking about lineage-based reparations, because that's the buzzword. That's the hot topic of the day. Lineage-based reparations would still just be race-based. So let's listen to what they say.
Because the mayor said it's not just going to benefit foundational Black Americans, but what other...
Doesn't the fool get what he said?
Exactly, because here's the thing. What other group of people will reparations benefit? Because it's not by race. It would be about lineage. And if you go by lineage, it just so happened it would be foundational Black Americans, not Black immigrants, not Jewish people, not Hispanics, not all these other people of color. It would be foundational Americans and maybe some white people, but
and maybe some white people. Hey, she said it, not me. But here's my response. Here's what I'm gonna say. Even legally, this is incorrect. Courts allow reparations to be tied to documented historical harm, just like discriminatory housing policies, just like Jim Crow laws, or forced labor. even if the beneficiaries are mostly descendants of Black Americans. That's the whole point of a lineage. That's the whole point of harm-based frameworks. It doesn't target the group. It targets the injury, not the race. So again, strict scrutiny doesn't automatically block this. In fact, this is exactly how constitutionally defensible reparations programs are structured. Constitutionally defensible reparations programs. Dana and Joe's argument here misunderstands the law. Now, I don't know why Dana and Joe keep misunderstanding and misrepresenting the law and these facts. I have no idea why. Other than the fact that they can't apparently seem to stand, they can't stomach Democrats, of whom Mayor Brandon is one. And he goes, so you hear what the fool is saying? That fool is standing on constitutional legal grounds. You are not. It seems like they're just so far down the black Republican sellout rabbit hole that it's their job just to throw out hogwash and hope you sop it up with a biscuit. They claim it's race-based when in reality it's harm-based. Now, yeah, it has race as a correlating factor, but courts have upheld similar frameworks. So, again, they're talking out there. Y'all know what I'm trying to say. Now I'm gonna push a little. I'm gonna go further. Let's get to this next section. And if you haven't guessed it yet, don't think I'm against reparations. I think they are against reparations. But let's see what else they got to say. And you see him up there holding his head. He got me holding mine. So what else he got to say?
Oh, as far as him saying he don't remember Clarence Thomas ever doing anything to benefit Black Americans, well, for Clarence Thomas to say, let's not have race-based, eliminate race-based, technically that does help Black Americans.
Well, that was the whole civil rights thing, to eliminate race-based discrimination against the class of Black folk. And so you wanted that? That's what all these people died for all these years and decades leading up to the 60s. And you want to turn around and reverse it? What kind of fool are you?
Because it wasn't about Black.
Now let's pause. Let me come on back to the big screen. Now this is what I'm gonna say. They need to they need to bring a lawyer onto their show, because I mean, Joe Brown ain't one anyhow. But let's unpack these comments that they made. Joe and Dana are claiming that, of all people, Clarence Thomas helps Black Americans because he wants to eliminate race-based distinctions. Now, eliminating race-based distinctions sounds nice on paper. I can't even say that Clarence Thomas wanting to help Black Americans sounds nice on paper. But what they're arguing for, in effect, in all actuality, is colorblindness. And they're saying to be fair, fairness is equivalent to colorblindness. Like the Statue of Liberty with the eyes behind the veil. The problem is history. The problem is law. and the history of law, they tell a very different story. So let's remember, the original Constitution was technically that colorblind fairness that they saying they want to get to or go back to in the MAGA world. It said nothing about race when it comes to rights. And yet, if colorblind law were enough, why do we need the 13th Amendment and the 14th Amendment and the 15th Amendment? Happy Black History Month to you. Why do we need the Civil Rights Act? Happy Black History Month to you. Why do we need the Voting Rights Act and affirmative action and a whole pipeline of other legal protections? Because colorblind rules all by themselves, sitting on a pretty piece of paper, don't protect Black Americans from systemic oppression. Happy Black History Month to you. Here's the constitutional nuance that they seem to be forgetting or stepping over or sidestepping. Thomas's philosophy, Judge Clarence Thomas, Thomas's philosophy is to treat everyone the same and reject race-conscious remedies. Now, yeah, for white folk, that might sound fair in theory. But remedial programs, and keep in mind what I said, remedial means programs that remedy. It doesn't mean slow people. Programs that remedy harms like reparations. That is a framework, that would be a program, if ever implemented, that addresses remedies for harms to an injured group. And they exist precisely because treating everyone the same historically hasn't worked for almost any non-white American group. You almost have to be the WASP for that to work. It ain't helped that much for the brown, the red, the yellow folk. I love the crayon box. It definitely has not helped for African Americans. Or if you prefer the term Black Americans. Strict color blindness often blocks the very tools designed to repair harm. Just like Edward Bloom preventing African Americans from holding a contest that would help Black women start businesses. Now, I'm begging y'all, just put on your critical thinking skills caps for a hot second. Because we can't just keep letting them play in our faces like this. Like, I told y'all, I mean, I'm a scholar if nothing else. And I share this regularly, not all the time, but I mean, I am a scholar now. You know, I ain't got to run up in, well, I've done this and that. But I mean, I know what I'm doing. If nothing else, I'm not a scholar of law, and never will claim to be. I'm a scholar of words. I know what words mean. I know how to mince words. So when Joe says, technically that helps Black Americans, what he's really doing is ignoring the entire historical context. The same way people ignore context when they start screaming sound bites that they heard 10 years ago. Civil rights law wasn't just about eliminating discrimination. It was about fixing. Nah, it was about repairing centuries of structural inequities. Nice big fancy word for harm. And in practice, Thomas's rulings and his whole philosophy always prevent reparations, always prevent repair, and all other targeted remedies. Okay, now I'm gonna say all other targeted remedies. So the bottom line is this: the argument that Joe and Dana and Judicial Watch and Edward Bloom and others, Clarence Thomas, this argument is misleading. Now, specifically, Dana and Joe are trying to spin colorblindness as inherently beneficial. But anyone paying attention to history, anyone paying attention to the Constitution, and if you're paying attention, or if you do some research, if you start reading up on case law, then you know that without race-conscious remedies, Black Americans are left with empty promises. And strict equal treatment on paper never plays out in reality. And I'm just going to keep saying it this way. Colorblind laws is not what got the Japanese their reparations. Colorblind laws is not what got the Native Americans their redress, whatever you call their redress, whether it's the reservations, whether it's the casinos, or what have you. Now, whether they call it reparations, or they call it repair, or they call it redress, they all got what was owed to them. I'm not saying they got all of what was owed to them, but they got what was owed to them based on the harm that was done to them. And this is why what Dana and Joe, this is what they're selling. The eliminating race-based distinctions. Somehow that automatically helps Black Americans. This is the wolf ticket that they're selling. It's not just misleading. It ignores every precedent where communities got actual justice and repair. Colorblindness alone doesn't undo centuries of targeted oppression. Never has, never will. Now, if you feel me, hit the like button. Keep sharing this. If you don't, drop a comment. Because I'm going to go further. Let me see if I can pull them up again. Just bring these clowns back to the stage. And let's see. Next little section where they start bamboozling everybody. So here we go.
And not the injured people.
Yeah, what you're talking about is this. Judge, how come they get a Japanese reparations after World War II? I said, you are misreading it. Enlighten yourself. They said we violated the Constitution because these individuals were Japanese, and without due process of law, we locked them up, deprived them of their liberty. We know who they are because every single one of these people is recorded by name, circumstance, previous place of residence, and where they...
Okay, let me see. Let me come back to the big screen. Let me see. Come back to the big screen. It might be not the... So let me see. So that ain't the section I was trying to play. I think I already talked about why they was wrong about the Japanese Americans. Let me see where that other section was. Let me see. All right, so I don't have that clip pulled up. Let me see if I can find it.
They were kept in a prison camp just because of what...
Injured people.
How come they get a Japanese...
Nah. That ain't the right section. Well, let me see. So, I don't know where that other section is. Well, if I don't have the other section, then I'm not going to comment on it because I'm not going to. I'm going to do it this way. So later on in the script, he says, he starts taking these pot shots. And he says, if you disagree with him, I guess your grasp of education is too low for the 21st century. And we get stuck on stupid and we don't understand. That's what I got a problem with. Now, I want to slow this down and unpack it carefully. Because first, Joe is doing exactly what Dana has been doing all throughout it. He's blending a technically true legal point. And when I say he's blending a technically true legal point, this is what I'm talking about. He says, you change a couple of words and technically you're fine, but you ain't gonna get it. You gotta follow Clarence Thomas and the Constitution if you want any hope at all. So he's technically true. He's blending a legal point with misleading rhetoric. Here's the truth. It is true that courts care about how you frame reparations programs. Race cannot be the sole criterion. And I don't think anybody who is doing the work, now we may be talking about it in the community as if it is all based upon race. But that's the common man. The lawyers don't go into the court that way. So the truth is that you must frame your programs correctly. Race cannot be the sole criterion. The program must be tied to documented historical harm. But that's why harm, that's why injury, that's why lineage-based frameworks actually exist. Like Evanston's housing reparations plan. But here's where they go off the rails. Joe's claim that you got to follow Clarence Thomas to get it. That's purely political posturing. There is no legal requirement to adopt Thomas's colorblind philosophy to win reparations. Courts have upheld race-conscious remedies under strict scrutiny, as long as the program is carefully tailored and narrowly addresses the harm. What they are doing is a gross oversimplification. Legal language matters, yes, it does. But the substantive framework matters more. So when you tie reparations to historic harm, to documented harm, that's what the courts actually evaluate, not lip service to Thomas's philosophy. And other legal beagles have already come out to say it would be a fool's errand to follow Thomas's philosophy. And this whole you ain't gonna get it fatalism. Judge Joe Brown is using his, I said I wasn't gonna call him that no more. Joe Brown is using his position, his elderly status, his background as a legal individual, as a judge. He's using that to intimidate people. History proves otherwise. And this is what he just doesn't get. Japanese internment reparations, Native American redress, and other remedies didn't rely on colorblind purism. They didn't do it in theory. They didn't do it rhetorically. They didn't do it legally when they went into those courts. And they succeeded because their cause was clear. Their paperwork was straight. They had the documentation, and legally they framed everything around the injury, not the race alone. They didn't go in there and say, we need these casinos because we Indians. We want our reservations because we Native Americans. No, they documented the harm that was done to them. Their race was just a correlation. It wasn't the substantive. So the legal takeaway, you do not need to adopt Clarence Thomas's legal philosophy. Especially when you're trying to structure a constitutionally defensible reparations program. Now, what you do need is a clear link to historic documented harm. Now, the only people that have that are the people that do not claim to be Indians, the people who do not claim to be descended from enslaved Africans, or who don't disavow, I should say, because the historic documented harm lies amongst the people who are descendant from those enslaved Africans who got treated to all the other systemic harms. You carefully tailor your argument to meet the strict scrutiny standards, and you use strong legal advocacy inside the court. You don't rely on Dana and Joe. Ain't no lawyers gonna go in the court with Dana and Joe in the briefcase. Now, Dana and Joe's presentation is harmful. It conflates technical compliance with the Constitution with following Judge Thomas. But they're doing it on purpose to make you think, to give you the impression that fighting for reparations is impossible, when in reality it's just a matter of well-structured law and evidence. And that's true whether you're talking about the state by state, the city by city attempts, or the federal one that everybody keeps running away from. Now, if you disagree with me, that's fine. Show me where I'm wrong. Show where I'm wrong. I don't have a problem with that. So, but let me just, in conclusion, the video by Joe and Dana isn't just wrong about the law, though it is. It's misleading. They're misleading you about who Judicial Watch is. They're misleading you about what the actual lawsuit for reparations and etc. actually alleges. They're misleading you about how equal protection doctrine works. And they're misleading you about what reparations frameworks looks like under constitutional analysis. This is not just my opinion. This is grounded in documented legal actions. Anybody that wants to do research, you're open and you're welcome to do it. But you don't run off half-cocked based on what Judge Joe Brown said or what Judicial Watch said. So what I am saying is a informed perspective, the proper perspective, grounded in documented legal actions, actual lawsuits, and constitutional text. You notice they ain't said nothing about actual cases. They just riffing. Now, ladies and gentlemen, brothers and sisters, if you found any value in this, like the video, subscribe if you haven't already, share this video with somebody else that wants to have this conversation about reparations. We need to have a more informed baseline so that jackals don't pull the wool over our eyes. So that we're not just debating talking heads, we're actually defending the truth with the law. Now, before I get out of here, I'm gonna get a little polemic. I'm gonna get just a little. I want to address something. I want to fix a couple of things, just in case the illegal beagle finds the video and wants to come all in here pedantic like. So let me just say, hold on. I've given you my spiel. I already know at least some of the things that somebody might say. So let me maybe try to let me CYA. And I'm going to say this with love, and I'm going to say this with clarity. Because all throughout this thing, hopefully one of the reasons I was trying to show, the video and their comments, of course I'm being rhetorical at sometimes. Sometimes I'm rhetorical, sometimes I'm being legal, sometimes I'm doing a little bit of both at the same time. And I know there's going to be scholars that would say, well, actually. And one of the things that they like to point out, the original Constitution was racially neutral in language, but structurally racialized. Yeah, that's cool. That's true. I know that. That's the academic version. Let's keep it funky. Because I think most of y'all know what I'm saying. But this is what I mean. Colorblind language never stopped slavery. So if you are a pedantic scholar and you want to say, well, the 13th Amendment explicitly bans slavery by race. Thank you, pompous prig. Thank you, you sophist. Pettifogger. I told y'all I was a scholar of words. I'm a black nerd. Blurred if you know what's up. And I love me some spelling bee words. So allow me to reiterate. Colorblind rhetoric never stopped slavery. It took a whole civil war and the 13th Amendment explicitly targeting racial bondage. Colorblind language never stopped Jim Crow. It never stopped redlining. Colorblind language never stopped mass incarceration. Colorblind language never stopped police brutality to this day. Colorblind language never built black wealth. It's trying to actively prevent it. Colorblind language never repaired black harm. So when anybody, this ain't just for Joe and Dana, when anybody tells you neutrality is the answer, it's just as dangerous as I believe in states' rights, because underneath the veil, all the states' rights activists, what was the right that they were arguing in favor of for their state to uphold? The right to keep us enslaved. So you can believe in the states' rights all you want to. That's just a cover-up for racism, white supremacy, and the enslavement of the African in America. So what they're really telling you is, when they say neutrality is the answer, they're telling you don't touch power. They're telling you don't touch structure. Don't touch history. Don't touch repair. And I'm telling you the opposite, because justice ain't neutral, and neither is repair. Truth has never been neutral. In all liberation, our liberation damn sure ain't ever been neutral. Now with that, I'm gonna get on up out of here. I thank you for showing up, for joining, for watching, for paying attention, for leaving a comment in the chat room. Leave a comment on the page. And I'm gonna holler at you next time. This is your brother Shabazz, sometimes Professor. Peace.